So the Restatement of the Law of Liability Insurance project is broken down at its most basic level into 4 chapters. So the first chapter is sort of general contract law principles. The second chapter focuses more on the management of the claim, the duty to defend, the duty to settle.
The third chapter, we call that the general principles of the risks insured, and so that tries to address general topics that are across all kinds of liability insurance. What's an exclusion, what's a condition, what's an insuring clause, how do we deal with deductibles and limits, what happens when there's more than one insurance policy on the hook. And then chapter 4 is going to address, we might call it a smorgasbord. It includes bad faith liability, remedies, the question of under what circumstances are insurance policy terms non-enforceable. And then the fourth topic, which I think is really important, is the question of liability for insurance brokers. So those are the 4 chapters.
There are many examples of areas of insurance law, either where the law itself is unclear, or the reasoning that courts are using could be sharpened. One area that I've spent a lot of time on involves the duty to settle. There is a common law duty on the part of insurance companies to act in good faith with respect to policyholders in circumstances in which the insurance company is given by contract the right to decide whether or not they're going to settle a case that's been brought against their insured.
One of the innovations, and it's an important innovation that we make, is that we don't call it the duty to settle. We call it the duty to make reasonable settlement decisions, because we want to emphasize that that's really what the duty is. The term duty to settle is a shorthand that you started using in law review articles and even some courts, but there's not a duty to settle, because sometimes a case can't be settled. There's a duty to make reasonable decisions in relation to settlement. And so I would say and I would say that although the legal rule that we've adopted is not an innovation, it's the mainstream rule. It's the disregard the limits rule that was first articulated by then Professor Keaton, then became Judge Keaton. So that's not an innovative rule, although we think it's the best rule. But this way of emphasizing that it's about the duty to make reasonable settlement decisions, I think will clear up some miscommunication that courts have had.